What is a notice of proposed action in probate?
Oh, you mean a NOPA?
Yep. We'll answer that right now. Welcome back to the channel. I'm Brendan Moore, California Realtor and Certified Probate and Trust Specialist by the California Association of Realtors.
And I'm Bill Heyman. I'm a licensed professional fiduciary, a licensed California real estate broker, as well as a registered and bonded California legal document assistant specializing in probate.
Please like this video, subscribe to our channel. Want your probate done for no fee? Every day we help people save thousands of dollars and eliminate headaches with our one-of-a-kind probate administration service and real estate listing combo in California. Please reach out to us with any questions. Comment on this video. Our contact information is below. Email, call, text, because we can help you. So let's get into this. What is a notice of proposed action?
Sure. The notice of proposed action, or a lot of times in the probate world, it's called the NOPA. It's an all-important document that you gotta have during a real estate sale, especially if you've got full authority. You don't need it if you got limited, but if you got full authority, which is most of the cases, you gotta have this form, you gotta have it done right, or else title won't accept it and you're not gonna close escrow. But basically it's a two-page document, well, three-page document, let's say, that basically describes the terms of the sale, and all of the heirs of the estate have to receive a copy of this document. And the document has two places where the heir could sign if they want to. There's one block they can sign that basically they're saying, I consent to this sale and the terms that are described in the document. There's another block that you don't really want them to sign, which says, I object to the sale and the terms of the document. Best scenario is the heirs sign the consent line and send the document back to you. If they do that, you're home free in terms of getting the sale done. However, if they sign the objection line and send it back to you, that puts a wrench in the whole process. You got to go through the court confirmation process to get the sale to go through. There's a third option here, and that is you mail out the notice of proposed action form to the heirs, and they do nothing. If 15 days go by and they don't sign the consent line or the objection line, and they just do nothing, then the court considers that consent. And you can go through with the sale after that 15-day period goes by from the date of mailing, 15 days, and title will accept that. You have to also file a document with the court, which is called a proof of service by mail of the notice of proposed action. It's basically a document that is signed off by someone that's not a party to the probate. It basically says, hey, on September 1st, I mailed a copy of this document to these people. You give the names and addresses, and you file that with the court. Title will also want a copy of that because they need to know that the mailing took place and the 15 days went by and nobody objected. There's one other option here, which you can avoid the notice of proposed action altogether. There's a probate document called a waiver of notice of proposed action. So if all the heirs are in agreement ahead of time and they all know about the sale and they just want it to go through, you can simply send them this document called a waiver of notice of proposed action. They sign it. That's it. They're basically saying the sale can go through. You don't have to worry about the 15-day period and the mailing of the notice of proposed action. I know that's a lot of information I just threw out there in a short period of time. The NOPA is an extremely important document. You got to have it, or some form of it, in order to get a sale to go through in a full authority situation.
Now, what would you say is maybe the most common scenario when you've issued a NOPA, whether it's the waiver or getting them signed and sent back to you?
Yeah. I would say the most common situation is you prepare the notice of proposed action, you mail it out to all the heirs. They don't do anything. The 15 days go by, and that's it. The sale will go through.
Yeah, so
that's the most common.
That is what I've seen as well, yeah. Which is why, and this gets into why it's very important to hire a realtor who knows what they're doing in probate, a very experienced realtor in probate, because a lot of them have never heard of this form. A lot of just, if it's a realtor who's never worked in probate before, maybe they have worked in probate before, they just never even realized this document existed, because it's not something I ever see as a realtor.
Right.
It doesn't go in my file. I don't fill it out as the realtor. It's on whoever is really probating the estate, usually the attorney or non-attorney probate administration service like what Bill does. And if that's not done quickly, then it's going to delay the sale. And if you know anything about real estate sales, there's an escrow period. And the escrow period is from what means the date of acceptance of the offer to when it closes. And usually that's 30 days or less. A lot of times it's a fixer, they want to close really fast. And if the notice of proposed action isn't mailed out quickly, then you could be delaying that sale significantly and not even know it until you get to the very end. And there's serious ramifications that can happen when you delay a sale. A buyer could lose their rate lock, and they may have the moving truck all packed up. There could be all sorts of bad stuff that happens. So one thing that you want to make sure of, whatever realtor you're using, make sure they know what a notice of proposed action is, and make sure that once an offer is accepted, that your agent and probably yourself as the administrator or executor reaches out to the probate professional, whether it's the attorney or whatever service you're using. Maybe you're doing it yourself. Get those out immediately. We like to tell people, whenever I get an accepted offer for one where I know that we have to send out the notice of proposed action, I always tell them we can close in as fast as 18 days because it usually takes a few days to prepare those documents, mail them out, and then there's the 15-day grace period.
And one thing you're bringing up, Brandon, which is critically important, and you know this as a very competent probate realtor, I've had situations where I'm probating the estate. I'm not the administrator of that particular estate, but I'm helping the family. I'm helping them with the paperwork. And the realtor and the administrator, they get an offer that comes in and it's accepted. They don't tell me. 2 weeks goes by, 3 weeks go by, and then all of a sudden the realtor or the administrator calls me and says, "Hey, we're supposed to close tomorrow." I said, "You're supposed to send me a copy of the signed agreement so I can get the NOPAs out." There you go. There's a delay in the process.
That doesn't surprise me that would happen, because if I didn't know the probate process, I wouldn't know that I had to reach out to you and tell you this stuff.
Exactly.
And how is critical. Day one, date of acceptance. What do I always do? I always send you a copy of the contract.
Absolutely.
And that's what has to happen, because then I know that you're going to get those out. Now, you might think that that's going to automatically happen though, but with an attorney. But as a realtor, if I'm dealing with if I'm not working with Bill, I'm working with different attorneys, and there's a lot of great attorneys out there. But some, it's not often not the attorney, it's a paralegal or somebody working in their office. They don't get to it for weeks. I have to call them, be on them. So it's not just a matter of sending it to them and thinking they're going to take care of everything. Letting them know this is the timeline. Because the real estate world and the legal world is two different things. Real estate world, we have very set, short contractual guidelines. Legal world, it goes along a lot longer. There's continuances. There's all sorts of things, and you just want someone who's going to get things done fast.
Yeah. I have worked, as I said, in the past with realtors who are not familiar with the probate process, and it's very, very difficult to get things done because they don't know. They just don't know how probate works.
So there's just one little piece of many, many pieces of probate real estate, why you really need to hire people who are very competent. And it's really great if you're a probate professional, the person probating the estate, attorney or non-attorney probate administration service, knows the real estate side as well. In that case, Bill's a great one. Please give us a call if you need that service. Our information is on the channel. Well, that's great information, Bill. I think what people really need to know is maybe how to hire a probate realtor.
Yeah.
And that video is going to be linked next. It's going to appear right above Bill's head, so click on that right now.